start the session,
Oh,
ma'am.
okay.
Thank
Thank
you
you.
so
Thank you. Participants, I have already shared the today's session's PPT, PDF, both the PDFs in the group. Wait, I'm just sharing the screen. Meanwhile, you can also open the screen in your device. We will share today the draft of the arbitral award and what is the procedure for the arbitration. It's from sending the notices till the arbitration award is there. So we will discuss that also. What is arbitration? We have already discussed yesterday, but in the today's class also we will also discuss few of the glimpses that what are the steps are being there regarding the arbitration. As we all know that if there is any kind of a suit being filed in the court, then what happened? Then the summons are being served to the defendant, okay, for the information that this has been the suit being filed in this court and you have to appear. These are the certain allegations being made. Same way in the case of the arbitration procedural, also there is a notice being sent. So I think the screen is visible to you all. This is with the what is arbitration and what are the stages of the arbitral procedure. So this particularly, actually there were two things in the schedule for today. There was a draft in the title of the class and there was a theory in the next explanation. So first of all, we will discuss with the theory. First, we already, and meanwhile, any student want to ask something, please feel free to ask related to the arbitration. Because arbitration is the nowadays a very important trending regime in the case of a in the aspect of law in the case of a dispute resolution. Arbitration we already acquainted with is a dispute resolution mechanism, alternate mechanism there where we can prevent from the litigation, where any of the parties can resolve their disputes outside the court, and there must be the, as we all know, there is an overburdening of the cases. So in the time, in a very peculiar time zone, in a very efficient and amicable manner, the parties can resolve their disputes. There are certain stages for the arbitral procedure. So there are certain stages means that certain things are being followed so that the dispute can be resolved by the arbitration proceedings. We will just give the brief to the same. Now the stages of the arbitration, as already mentioned in the screen on the screen, it's like a arbitration clause or the arbitration agreement. Arbitration clause or arbitration agreement in the contract means that what are the things that would be stated in that in the future, if the dispute is there, then they can resolve it through the arbitration procedure. And the arbitration, when we draft the arbitration clause for the same, the person who is being drafting it must be very careful, and just the arbitration draft clause must be very and detailed, because it should ensure all the possibilities way possible that if any of the dispute arises, then that could be resolved within that ambit. Regarding that, there is a case law also, South Delhi Municipal Corporation versus this SMS Anam, that always a private limited 2018 case, where the Supreme Court already decided and said that the clause number 16 of the agreement was held by the court, that arbitration need to be a process that is need to be understand that it's a process by which the dispute is being resolved, and thus arbitration is chosen such that and acceptable to the both sides of the arbitration agreement. Okay, there are certain cases on the same also. IBI Consultancy, Indian Private Limited versus GST Limited cases there, where it's also that the cardinal principles of the Arbitration and the Conciliation Act, the parties are feel free to agree upon the number of arbitrators. There must be the odd number. There is no as such circumstances there. Now the another thing is the statement of the claim. That is a very important part, because section number 23 particularly deals with the statement of the claim, that within the time period that is fixed by the parties, the claimant must state supporting facts about the claim, point of issues, and reliefs. Now the hearing of the parties. Now, this is the step where the arbitration particularly started with. The above two part are in the dealing with the drafting upon the same. So, arbitration process particularly starts with the hearing of the parties. So, hearing of the parties, it's like preliminary hearing or the primary hearing and the exchange of the information stage. This is the first step. Means first the arbitrator for the any of the dispute to be resolved by the method of the arbitration, we need to appoint the arbitrator. So first of all, it is confirmed and that this person will be the arbitrator and that person is appointed. Then the primary hearing of the arbitration begins, and in which the parties can call the arbitrator, they can fix the schedule and so on. This is already mentioned upon the slide in the preliminary hearing and the exchange of the information stage. Now, when the preliminary stage is there, then the issue of the disputes are addressed, and when the issues are being addressed, then the preliminary meetings, the exchange of the information is also done. Then both the parties come together and they exchange the informations and so on. There is a stage of hearing also, where there is in the case is presented by the arbitrators by the party. The process can take place in person and can over with the telephone also and so on. Or written documents are also there. So the parties also submitted their written arguments to the arbitrator. So it is convenient and easy for the arbitrator also to take any decision. Now comes the award stage, when the hearings are being completed. Means that the arbitrator hear both the sides. Then the arbitrator determines that there are no more evidences that need to be presented. There are no more uh, things, no more conditions, no more hearing or no more like facts to be exclaimed to remained, that must be get the attention to. So now it's the date that is fixed and the award is issued. Now the another stage comes the arbitral award. Arbitral award means that the arbitration hearing is completed. The arbitrator determined that what is the requirement for the parties to settle the disputes and so on. So arbitrator settle or gives kind of a order or finally kind of a judgment, but we did not call it a judgment. It's kind of an award. It means that the relief, if there is any kind of a monetary relief also, or there is kind of a non-monetary relief or incentive relief is there, then those are being given. There are certain essentials also. Essentials means what are the essentials? The essentials can be the award must be in written format and duly signed by majority. Here one word is mentioned, that is the majority or by all. Majority means first of all, both the disputed parties, all the members of the disputed parties will sign. It means here, and by all means the arbitrator would also sign. Now next is yes, the date and the place of the award should be mentioned, that on which place, on which date, at which time. Just like we mentioned, it like verified upon the suit also. Now, date and place is there along with the signature of the advocate and the party, the plaintiff and the defendant, same as here also. Now, what are the reasons that are being a decision is being made, and unless and until the parties agreed, if the mutual agreement is there, there is no need to mention the reason, because parties are mutually agreeing upon something. But if the parties are not mutually agreeing, but there is a thing like the arbitrator comes with a judgment decision that okay, the finally the mutual settlement is there, then that would be recorded as an award. Award should be certain. Final award should not be vague, uncertain, and unambiguous. It should not be ambiguous, and so on. And but there is no such need for the registration like final judicial decree, and it must be enforced in a safe way. So this is are the certain requirements for the arbitral award that must be just during the arbitral procedure must be followed. I'm scrolling down. There are certain challenges also, like because when any of the arbitrator, if take it in a very easy way, layman way, if you give any of the judgment or any of the solution to any of the party, then the other party would gonna respond something. So it's like when they're challenging award, the party in the whose favor the award is given, then the arbitrator need to wait for a 90 days period and the other party have to if the other party challenge the award or what, means that the aggrieved party or the party in whose against the award is being issued. And section number 34 also deals with the same. Now there are and dear students, if you are getting confused with that what why I am not teaching each and every section in detail, so no need to just go through the detail of the each and every section, because the arbitration particularly you studied in the clinical paper also. There is a ADR paper, a clinical paper, where you discuss about the Lok Adalats and Arbitration Conciliation Act. And moreover, here two things are just important. That is, first of all, the arbitration. What is the meaning of arbitration, conciliation, and mediation? And second is what is arbitral awards, and what are the cases being adjudicated by the process of ADR mechanism, and what is the Lok Adalat. Lok Adalat, I think every law student might be heard of. There are certain vital other elements also of the arbiter. There, for example, seat and the venue of the arbitration. The venue plays a very crucial role where the parties meet, where there will be a arbitration. Now there is arbitration room in the every court and district courts. What is the cost of the arbitration? Because the arbitrator will also have charge some of the fees and all. Who will pay, or the either both the parties will pay mutually. Now there is any limitation also. Yes, the limitation act is applicable there, and limitation act is applicable. It means that the section number 43 subsection number 2 of the act clearly state that on the which date of the cause of arbitration occurred, the period of limitation began to run for the claimant to invoke the arbitration clause, and that period sometimes is for the 90 days also. Now there is a final award. The final award is when the entire arbitration process is completed, the judgment is being finally done, the dispute is being resolved, then the arbitrator must make the decision. Yes, you can also challenge in the court during the 90 days period. The right party can challenge, but in most of the cases it doesn't challenge at all. Now there is enforcement. For example, for the decree, and you just file the execution petition in the court. But in the case of an arbitration award, there is no such thing that you have to get it enforced. But yes, sometimes it is required to be enforced. So it's just like if the court can also set aside the arbitral award if the parties to the dispute are some incapability beyond the scope of submission of the arbitration and so on. But rather than the in the arbitration particularly, the parties mutually agreeing upon something, so that in that case there is no as such need. Now comes the another important thing, that is a domestic award. So domestic means the award within the country, and within the that is within the periphery geographical regions of the country. Foreign arbitration means that is given under the New York Convention, and that is also being adopted by the UN. So that is a foreign award, that is just like resolving the disputes that are arising out of the legal relationships, or Geneva Convention also talk about the same, and these are kinds of a foreign regions arbitration proceeding. So this is all about the basics and the law behind the arbitration. Now we will directly, if anyone have any question regarding the theory, please let me know. Else I will share the another draft of the arbitral award. That is what the class is. This class is about. Yes, please. Anyone want to ask anything about the theory? Uh, are you acquainted with the theory? You must read the theory. I have already shared with you all. Yes, Ranvijay, very active student of the class. Uh, yes, okay, Anamika also. Yes, the I will share the now share the draft. Okay, wait for a second, just. No one have any question regarding the theory? Wait, I'm just sharing the screen. Okay, Akash. Yes. The draft is visible to you all. If you search out upon the internet also, if you acha, okay, what is the difference between the mediation and the arbitration, Yuvraj? Yes, though both are the different types of the mechanism of alternate dispute resolution. In the arbitration particularly, it is just resolving the dispute outside the court, and it's just kind of a private litigation. And where the in the case of arbitration, you can also say that the who the person who is appointed as arbitrator, his decision is binding. But when we comes to mediation, then the mediation is a very voluntary kind of a thing, you can say, and the decision is also not binding as such all. And when we discuss about the mediation, the final decision is just both the parties are mutually agreeing. The conflicting parties are just like they are agreeing a agreement or agreeing a thing. But in the case of arbitration particularly, yes, there is a thing like a mutual understanding or a mutual agreement. But the arbitrator just when provide the arbitral award, it's just like reaching a verdict. It's just like they are analyzing the case details. They are just taking the arguments in the written form and all. And first of all, the foremost, both are the different mechanism of alternate dispute resolution. But in the case of a mediation, it's more about the dispute resolves in a category of settlement. Yeah, and it's just not like imposing any kind of a solution, and until and unless the parties are signing any of the agreement and so on. But in the case of a arbitration, it's just like parties are bound to just follow the what the arbitral award is. Anamika Sharma. So parties can question the arbitral award if they don't agree. First of all, it's not parties, it's party, because two parties are there, na? One is the victim and other is the um, alleged. So the if the any of the parties is like aggrieved of the same, that for example the arbitral award just gone in the favor of one, then the another party is aggrieved, so within the 90 days they can challenge in the court. But this doesn't happen practically. When the arbitration is already following, then what is the utility that okay, for the arbitral award also you are just going to challenge? But yes, there is a provision for the law. Just please keep in mind always, if they are not agreeing, then they can go to the court and challenge the arbitral award. Okay. Yes, anytime, Anamika, no need for the thank you at all. I'm just here to clear all your doubts as much as possible. Okay. Now, anyone else want to ask something? Then please feel free to put in the chat box. This screen is visible to you all. I know the font size is small. We try to zoom the screen the text so you can just read it properly. So yes, this is the award. This is the specimen of the arbitration agreement, and where two parties are just there. How to just do? I don't know how to zoom the screen in the PDF. Wait for a second. Okay, I think it's zoom in now. Yes, it's a specimen of the arbitration agreement to refer the dispute of the two arbitrators. So we will go by one the line that how. Now you must your mind will be like okay, we have discussed about the process, that how the civil suits are being filed, how the complaints are being registered, how the summons are being sent, how different kinds of applications or the petitions are being made to the court. So the now arbitration is also a legal process. It's also a process that is being regulated by the law, and that comes within the ambit of the Constitution of India only. You people are studying Constitution? I think everybody will be studying constitution. Yes, yes, very good, very good. And just try to be just make the constitution the best of your knowledge and belief. Okay, now there is a particularly, this is the specimen, which specimen is just like we have to state it, and this is the very sample, and most of the arbitration agreement are being prepared in the same way. It's like this is an agreement made and entered. First of all, the agreement is prepared, and second, that the parties are there. Into between, Mr. Party means A and party B on the date and the and year, whatever witness as follows, and the witness and whatever the witnesses are there, then will be mention it herewise. Now, whereas under differences and the disputes have arisen between the parties above mentioned, means both the parties that are being mentioned, Mr. A and Mr. B, regarding the matter of any kind of a matter is there. If a labor court and law, labor employment courts matter is there, a family dispute matter is there, contract matter is there, and the parties could not mutually settle the matter. So here comes another important aspect. Any one of you have asking me about the mediation? Yes, Yuvraj, you were asking me about the mediation now. So now you can understand the difference more clearly. The line here is mentioned, parties could not settle the matter mutually. Means that the no mediation was there, no parties can be just come together on a first single point. Okay, they are just conflicting parties are coming to a one end, but they are just like one is saying the right is right and the other is saying the left is right. So now here the arbitrator will try to make them both of them clear, and they will say whatever as per the circumstances is there. Yes, and now the parties agree that the matter has under be referred to the arbitration to obtain the award. Here, the judgment or the decree or the order is referred as an award. Now, first, for the purpose of the final determination of the dispute, the matter will be referred to this, who is nominated by one party, and here two arbitrators are there. That both the parties have appointed their own arbitrator. So there is no as such scene that the partiality is there. Next, nominated by the other party as the arbitrator, and their award shall be final and binding upon both the parties. Here it's clearly mentioned that the award shall be final and binding on both the parties. If the differences should arise between the said two arbitrators on the questions referred to them, the said arbitrator shall select an umpire, and the award to given by the umpire shall be final. And both the parties hereby agree that the award so given by the umpire or the arbitrator shall be binding upon both the parties. If the arbitrators also get confused, or they are just also like unable to just make any of the judgment or the decision, then they can appoint another arbitrator that would act as a and there could be, it's just like, okay, the third person may be there. A reasonable time limit may be fixed after consulting the arbitrators for the grant of the award by them. Okay, now the provisions of the Arbitrator and the Conciliation Act 1996, so far as are applicable and as are as not inconsistent or repugnant to the purposes of this reference, shall apply to this reference of the arbitration. So this is very important to mention, that we are strictly following the provisions of the Arbitration and the Conciliation Act. It is followed by the both the parties agree that they would cooperate, lead the advices, etc. Arbitrators appointed as appointed, and would be at the liberty to proceed with the reference to the ex party and so on. Because if there are certain conditions arise, non-cooperation, absence is there, then the parties here to agree that this reference to the arbitration would not be revoked either by the death or the either party or any other cause. Next, if the arbitrator or any one of them has chosen under this agreement become incapacitated either by death or the sickness or the disability, the parties retain the right of nominating substitutes, and no fresh agreement therefore would be necessary. It's an express stipulation that any award passed by the said arbitrator shall be binding. So these are the conditions, these are the things that need to be mentioned when we are preparing the arbitration agreement. Okay, so these things are this, that okay, everything is very crystal clear from point number 1 to point number 8. If the parties are absent, parties are non-cooperative, then the ex party reference will be given. If the arbitrations couldn't make any decision, then the umpire arbitrator would be appointed. And if the arbitrator has become incapacitated, or there is a death of the arbitrator, or sickness or disability, then the parties retain the right of nominating substitute, and no fresh agreement would be necessary. So one arbitrator will be there. Means these are the circumstances that can lead to, if there is anything that could lead to more of the dispute, so that are being mentioned. And this is must be signatured by both the parties, and both the arbitrators, it's a signature 1 and signature 2. That's all about the arbitration agreement being made. I think the arbitration agreement is clear to you all. I just hope that because this is a very easy thing. I think arbitration drafting, arbitration mechanism is the utmost reasonable, utmost easy thing, and it must be just like must be in the full-fledged manner, must be enforced in the legal system. This is a very easy way to tackle. It will just reduce the burdening, overburdening of the cases of the court. Also, it will be convenient for the advocates also, just to appear. It's convenient mostly mainly for the victims also, for the non-heinous crimes. Yes, I hope the draft is very how clear to you all. Yes, please start putting your queries in the chat box, please. Quite strange that no one have any query regarding. Everything is clear to you all.
Yes, ma'am.
Okay, Akash, good, good. Thank you. So, anyone want to ask anything rather than this arbitration? Because that's all for the today's topic. Any other law, if you have any query, then please feel free to ask me. Quite strange. No, 20 people, including me, are there in the class, and all are just sitting quietly. I understand the Sunday is about to over, so please come in the work mode. I understand it's a lazy, busy day for you all. You took a Sunday who studies on Sunday. Apology for the same that I asked them to arrange the class on today Sunday, because the classes couldn't continue on 1 or 2 days in the weekdays. That's why. And place practice. Okay, can I give you one task for today's, ma'am? As mediation is sent by the court, then it should be more binding. Actually, the mediation, Yuvraj, you are already saying right that in the mediation, the court only send the parties. Actually, mediation is just like, okay, make a attempt call, or make a final call, that the parties are just like agreeing upon something. They are just like settling, or they are just like mutually agreeing, or they are just like want to settle. Particularly, mediation is done most importantly in the case of a family disputes. If you are in the litigation of a family court, then you must see that in the, if the FIR is also lost in the 498A cases, means dowry cases also, then also at the somehow the mediation is being done, and it is started. Actually, mediation is just like both the parties can conclude to some of the basic understanding. Okay, some of the thing like they are agreeing upon something, they are trying to resolve the disputes. Because in the family matters, it is clear guidelines of the Supreme Court also, no need to break the family, either make an attempt. So it mediation is kind of a making an attempt that the parties resolve their disputes by mutual understanding, by clarification, by clearing their doubts, and so on. So it's not like a binding and all, because if the parties are not agreeing, if one of the parties just on their own stand that I won't listen to the other or I won't get settled, then how could it be binding? A mediation is not any kind of a judgment degree or award being issued. It's just like a counseling, where we can also say it's a counseling, that the parties are being just listened, they are being heard, and they are being just as requested to say something. It's like that. Yes, anyone? Yuvraj, I hope you got the answer. If something remaining, then please let me know. Mediation is more of a kind of a, as you all know, we see that बात करने से बात बनती है. Ma'am, but if they both amicably agree to something, after that they breach that. Yuvraj, you ask a very particular question. Actually, there is a guarantee of nothing in this world. So yes, once they amicably agree, then they will start mutually living together, or whatever the circumstance or whatever the thing of the situation or the case is, the dispute is resolved for that particular time period. If they just breach, then what would happen? They will again in the court, or they will again in the mediation room. It's like that. But nothing as such happens, because and no one want to be in the disputes again and again and again. Then they would be that mediation is failed, and they would be just like further the proceedings must be there. Mediation is more like बातचीत करके resolve करना, mutually decide करना and all. Yes, Yuvraj. Yes, anyone else? You people can ask me anything related to any other law also. I was just talking about the constitutional law also. Okay, you people tell me which is your favorite part or article that you would like to study in the constitution. Okay, that website is Supreme Court Observer is a website that particularly on the Sundays, I think Saturday or the Sundays, weekly publishing whatever is happening in the Supreme Court, their judgments and so on. Please follow that website rigorously. Either subscribe to their mailing list. It's very good for you all. Yes, Anamika, Supreme Court Observer is there. If you don't find the website link, I will share to you in the group only. So everything is clear to you all about the arbitration. It's a very easy thing. Nothing as such difficult or just to learn about like the CPC or or the BNSS. If everyone understands everything, then gives a thumbs up. So it will be easy for me also. Okay, okay. Thank you. And you can also watch the recorded sessions of if you are facing any of the doubt in the any of the class, and and whatever we have discussed in the previous 23 classes, if anyone have any doubt regarding the same, then please feel free to ask me. It's not that today I'm discussing the arbitration, so I can't be just taking your queries regarding the BNSS, or if you are studying the any aspect of the CPC and I won't solve that, you can ask me anything. Okay, about the previous classes also, because law is more or less about reading, writing, and the practices. It's more about reading, writing, and practice. Okay, so that's all for today's session, because topic is this much only. We'll meet tomorrow for sure with a new topic, new draft in the arbitration only. Till then, happy learning, stay safe, stay healthy. The legal Vidya is there. Yes, Yuvraj. And no need for the thank you. It's just my duty to teach you. Always your suggestions are welcome. The legal Vidya is there. Then please wrap the session, or else, dear participants, thank you so much for joining. We'll meet tomorrow with a new draft. Okay, thank you. You can leave the meeting. I think legal Vidya is not there.
We are there, ma'am. Thank you so much.
Oh, okay, okay, okay.
Yes, yes.
Okay, thank you.
Thank you, participant, for joining. Good night, everyone.
Thanks, legal Vidya. Stay